You slipped and fell at a store and filed a claim. But what if it gets denied? Do you still have options? In this video, I'll show you why businesses deny legitimate claims, what legal rights you still have in Florida, and the steps you can take right now to fight back and get the compensation you deserve. Hey, Attorney Patrick here from Hale Law. If you or somebody you know were injured and want to speak with an attorney you can trust, call me at 1-800-800-1414. The call is free and confidential, and we will walk you through how to fight like Hale so you can get the maximum compensation you deserve. First, let's talk about why the business denied your claim in the first place, because it's probably not the reason you think. Most people assume a denial means they don't have a case. That's exactly what the insurance company wants you to believe. The truth is, businesses deny claims for financial reasons, not because your injuries aren't real. Insurance companies make money by collecting premiums and paying out as little as possible. Every claim they can close without writing a check is a win for their bottom line, so they use predictable tactics to discourage you. They'll claim they had no idea the hazard existed, even though Florida law requires property owners to conduct regular inspections and discover dangerous conditions through proper maintenance. They'll call the hazard open and obvious, arguing you should have seen it yourself, even if the lighting was poor or your attention was naturally directed elsewhere. They'll try to shift blame onto you without investigating what actually happened. They'll cherry pick your medical records, downplay your injuries, and sometimes they'll simply drag their feet, hoping the financial pressure forces you into giving up or accepting far less than you're owed. Once you understand that these are strategies, not legitimate reasons, you realize your claim isn't dead. It just needs the right approach. So what are your actual legal rights after a denial? In Florida, property owners have a legal duty to keep their premises reasonably safe for customers and visitors. And when they fail to do that through poor maintenance, skipped inspections, or ignoring known hazards, they're liable for injuries that result, regardless of whether their insurance company denied your claim. Under Florida Statute 768.0755, slip and fall cases through things like spills, debris, or other temporary hazards require you to show the business either knew about the dangerous condition or should have known about it through reasonable care. Constructive knowledge, meaning the hazard existed long enough that any responsible business would have found it and fixed it, is enough. And here's something most people overlook. The denial letter itself is actually useful. It tells you exactly what defense the business plans to use, which means your attorney can target those specific arguments with evidence designed to dismantle them. And many denial letters contain factual errors or misapply the law, and those weaknesses become your leverage. Now, before jumping straight to a lawsuit, there are steps you can take that often resolve the situation faster. Your attorney can send a detailed notice of claim to the business, laying out what happened, documenting your injuries, and explaining why they're liable. This alone sometimes reopens the conversation, especially when the business realizes you're not going away quietly. At the same time, your attorney should be sending preservation letters demanding the business retain surveillance footage, maintenance logs, incident reports, and employee witness information. This is urgent because surveillance systems routinely record over themselves within days or weeks. If that footage gets deleted, critical evidence disappears permanently. When a business and their insurer see that you have legal representation actively preserving evidence and preparing a case, the calculus changes. They know that finding a well-prepared claim costs more than settling it fairly, and that pressure alone often leads to serious offers before a lawsuit is ever filed. But none of that works without strong evidence, and this is where the real case building happens. Start with the scene itself. If you haven't already, return to the location, photograph everything. Lighting conditions, floor surfaces, whether warning signs were posted, the approach path showing what you could and couldn't see before the fall. Take photos from multiple angles and distances. Your medical documentation is equally critical though. Complete records from your emergency visit, imaging results, specialist consultations, physical therapy notes, and your ongoing treatment plan all form the foundation, proving your injuries are real and directly connected to the fall. Any gaps in treatment or delays in seeing a doctor will get exploited by the insurance company, so make sure your medical timeline is airtight. Witnesses, too, can change everything. Other customers who saw you fall or noticed the hazard provide unbiased accounts that directly counter the business's version of events. Even employees may give honest testimony under oath about known hazards or inadequate cleaning procedures, especially when their statements are locked in through depositions. And don't underestimate surveillance footage, even if it didn't capture the actual fall. Footage showing the hazard just sitting unaddressed for an extended period or showing other people avoiding the same spot proves the business had every opportunity to fix it and chose not to. When it comes to negotiating after a denial, understand that insurance adjusters respond to preparation, not emotion. A well-crafted demand letter that tells your story, establishes liability with evidence, and includes a specific settlement figure based on comparable case outcomes sets the tone. It signals that you know what your claim is worth and you're not accepting less. Your attorney will go back and forth with the insurer, countering their offers, calling out weak arguments, and leveraging the strength of your evidence. Timing matters here too. Experienced attorneys know when to push and when to let the pressure of approaching deadlines do the work. Insurance companies often become far more reasonable when they realize litigation is genuinely on the table. And sometimes, litigation is exactly where the case needs to go. If the business refuses to offer fair compensation despite clear evidence, filing a lawsuit changes the entire dynamic. Once a suit is filed, the business faces court deadlines, formal discovery obligations, and the very real possibility of a jury verdict that exceeds anything they would have paid in settlement. During litigation, your attorney gains access to tools that weren't available before. Written interrogatories that force sworn answers about maintenance, procedures, and prior incidents. Document requests compel production of records the business claimed didn't exist. Depositions lock key witnesses into testimony under oath, and any contradictions or admissions become powerful ammunition. Expert witnesses can testify about industry safety standards, building code violations, and the mechanics of how your fall caused your specific injuries. When a jury sees all of that laid out clearly, businesses rarely like their odds. If a business denied your slip and fall claim in Florida and you're not sure what to do next, call us at 1-800-800-1414. The call is free and confidential, and we'll review your denial, explain your options, and fight to get you the compensation the business doesn't want to pay. When they try to shut you out, fight like hail. And if this video was helpful, hit subscribe for more legal guidance and check out our next video.